Termination of agency, covered under sections 201 to 210. From this topic, two important questions are often asked. First, what are the various modes by which an agency can be terminated? Second, whether an agency is terminated by the death of the principal or the agent. Now, let us begin with the introduction to termination of agency. An agent acts on behalf of the principal and under his control while dealing with third parties. This relationship is fiduciary in nature, which means it is based on trust and confidence. An agency can be created either expressly or impliedly, and even in situations of necessity or by ratification. In this relationship, both the principal and the agent owe certain duties to each other. However, since the foundation of agency is trust, if at any point this trust is broken or no longer exists, then the agency relationship may come to an end. So now, we will examine the various situations in which an agency is terminated and also understand the legal effects of such termination. Now, let us understand the general rule regarding termination of agency. An agent's authority can be terminated at any time. This is because the relationship between the principal and the agent is based on trust and confidence. If that trust breaks down at any point, then it is not reasonable to expect the principal to continue bearing the risk for any transactions that the agent may carry out, even during a notice period. So, the law allows the principal to terminate the authority whenever such trust no longer exists. Mode of termination of agency, as per section 201. An agency is terminated by the principal revoking his authority, or by the agent renouncing the business of the agency, or by the business of the agency being completed, or by either the principal or agent dying or becoming of unsound mind, or by the principal being adjudicated and insolvent under the provisions of any act for the time being in force for the relief of insolvent debtors. An agency may be terminated in the following ways. First, by revocation, that is, when the principal withdraws the authority of the agent. Second, by renunciation, when the agent himself decides to give up the business of agency. Third, by completion of the object, that is, when the purpose of the agency is fulfilled. Fourth, by the death or insanity of either the principal or the agent. Fifth, by insolvency of the principal. Sixth, on the expiry of time, when the agency was created for a fixed period. Seventh, by mutual agreement between the principal and the agent. And finally, by operation of law, that is, when the law itself brings the agency to an end due to certain circumstances. Now, let us understand termination of agency by revocation. Under section 203, section 203 provides that the principal may revoke the authority given to his agent at any time before the authority has been exercised, so as to bind the principal. In simple terms, the principal has the right to withdraw the authority of the agent at any time. However, this right is not absolute. If the revocation is done in violation of the terms of the agency agreement, then the principal may become liable to compensate the agent for breach of contract. Also, revocation need not always be express any words or even conduct of the principal, which is inconsistent with the continuation of the agent's authority, may amount to implied revocation. So, remember, the principal can revoke authority, but must do so carefully, otherwise, he may face legal consequences. Now, let us understand the restrictions on revocation of agency. Although section 203 allows the principal to revoke the authority of the agent at any time, there are certain important limitations. First, revocation must take place before the authority is exercised. That means, once the agent has already acted and bound the principal, revocation cannot undo that act. Second, agency cannot be revoked where the agent has an interest in the subject matter, as provided under section 202. In such cases, the agency becomes irrevocable to the extent of that interest. Third, where the authority has been partly exercised, as per section 204, the principal cannot revoke the authority in respect of acts which have already been done. In other words, revocation cannot affect the rights and obligations that have already arisen. So, remember, revocation is allowed, but it is subject to these key restrictions. Before exercise of authority, no revocation where agent has interest, and no revocation for acts already performed. Now, let us understand this concept with the help of an illustration. Illustration A. Authorize B to buy 1,000 bales of cotton on behalf of A and to pay for it out of A's money already lying with B. Now, B purchases the cotton, but in his own name, making himself personally liable for the price. In this situation, A cannot revoke B's authority so far as the payment for the cotton is concerned. Why? Because B has already acted and incurred personal liability on behalf of A. So, the authority has been partly exercised, and as per law, the principal cannot revoke the authority in respect of acts already done. So, remember, once the agent has acted and obligations have arisen, the principal cannot revoke to avoid those responsibilities. Now, let us understand. Illustration: B. A authorizes B to buy 1,000 bales of cotton on behalf of A and to pay for it out of A's money, remaining with B. Now, B purchases the cotton in A's name, and importantly, B does not make himself personally liable for the price. In this situation, A can revoke B's authority to pay for the cotton. Why? Because B has not incurred any personal liability, and therefore, no obligation has arisen which binds B personally. So, even though the purchase is made, the authority regarding payment can still be revoked by A. So, remember the key difference. If the agent becomes personally liable, revocation is not allowed. But if the agent is not personally liable, the principal can still revoke the authority. Renunciation of agency by the agent. An agent has the right to renounce his authority. He may do so either by refusing to act or by giving notice to the principal that he will no longer act on his behalf. However, this right is not absolute. If the agent terminates the agency unilaterally before fulfilling his obligations, then he may become liable to the principal for breach of the agency agreement. In such a case, the agent may have to compensate the principal for any loss suffered. So, remember, an agent can renounce the agency, but must do so carefully. Otherwise, he may be held liable for damages. Now, let us understand compensation for revocation or renunciation. Under Section 205, when there is an express or implied agreement that the agency will continue for a specific period of time, then neither party can terminate it without consequences. If the principal revokes the agency or the agent renounces it before the agreed time and without sufficient cause, then the party who terminates the agency must compensate the other party for the loss suffered. Let's simplify this. First, there must be a fixed time period for the agency. Second, either the principal revokes or the agent renounces the agency. Third, such termination is without sufficient cause. In that case, compensation must be paid to the other party. So, remember, if agency is for a fixed term and is ended early without valid reason, then the party at fault must pay damages. Now, let us understand notice of revocation or renunciation. Under Section 206, as per this section, when an agency is terminated by revocation or renunciation, reasonable notice must be given to the other party. If such notice is not given, then any loss caused must be compensated by the party who failed to give notice. Now, there's another important aspect. Even if the principal revokes the authority of the agent, this revocation may not immediately free the principal from liability towards third parties. Why? Because third parties may still rely on the apparent authority of the agent based on past dealings or representation made by the principal. Therefore, it is very important that notice of revocation should also be given to third parties as soon as possible. So, remember, reasonable notice is essential, both between the parties and towards third persons. Otherwise, liability may still continue. Section 208, which deals with when termination of agency takes effect. The law provides that termination of an agent's authority does not take effect so far as the agent is concerned until it becomes known to him, and so far as third persons are concerned until it becomes known to them. In simple words, termination is effective only when it is communicated. If the agent does not know that his authority has been terminated, he may still act in good faith, and such acts may still bind the principal. Similarly, if third parties are unaware of the termination, they may rely on the agent's authority, and the principal may still be held liable So, remember, knowledge or notice is the key factor. Without communication, termination is not effective. Now, let us understand. Illustration A. Under Section 208, A directs B to sell goods on his behalf and agrees to pay him a commission of 5%. Later, A sends a letter revoking B's authority. However, before B receives the letter, he sells the goods for 100 rupees. Now, what is the legal position? The sale is binding on A, and B is entitled to his commission of 5 rupees. Why? Because the termination of authority takes effect only when it becomes known to the agent. Here, B had no knowledge of the revocation, so his act, done in good faith, is valid and binding. So, remember, until the agent receives notice, his authority continues, and the principal remains bound by his acts. Now, let us understand. Illustration B. Under Section 208, A, who is in Madras, writes to B, directing him to sell certain cotton lying in Bombay. Later, A sends another letter revoking B's authority and instructing him to send the cotton back to Madras. Now, B receives the second letter, so he is aware that his authority has been revoked. However, B still enters into a contract with C to sell the cotton. Here, C knows about the first letter, but has no knowledge of the revocation. C pays the money to B, and B absconds. Now, what is the legal position? C's payment is valid against A. Why? Because, as far as third persons are concerned, termination of authority takes effect only when it becomes known to them. Here, C had no knowledge of the revocation, so he acted in good faith, relying on the apparent authority of B. Therefore, A is bound by the transaction and must bear the loss. So, remember, even if the agent knows, but the third party does not, the principal may still be liable to protect innocent third parties. Illustration C. Under Section 208, A directs B, his agent, to pay a certain sum of money to C. After giving this instruction, A dies, and D is appointed as the executor of A's will. Now, B, without knowing about A's death, makes the payment to C. What is the legal position? The payment made by B is valid, even against D, the executor. Why? Because termination of agency by death takes effect only when it becomes known to the agent. Here, B had no knowledge of A's death, so his act, done in good faith, is legally valid. So, remember, even death of the principal does not immediately terminate authority unless the agent has knowledge of it. Now, let us understand. Section 207. Revocation and renunciation may be express or implied. This means termination of agency does not always require a formal or written communication. It may be done expressly through clear words, or it may be implied through the conduct of the principal or the agent. Let's understand this with an illustration. A authorizes B to let out his house. Later, A himself lets out the house to someone else. Now, this act of A is inconsistent with B's authority. So, this amounts to implied revocation of B's authority. So, remember, termination of agency can happen either by clear words or by conduct, and any act which is inconsistent with the continuance of authority amounts to revocation. Now, let us understand. Termination of agency by completion of object. When an agent is appointed to perform a specific task or to achieve a particular purpose, then the agency automatically comes to an end once the task is completed or the purpose is fulfilled. In simple words, the agency exists only for that particular objective, and as soon as that objective is achieved, the authority of the agent comes to an end. So, remember, no separate notice is required. When the object of the agency has already been completed, the agency terminates automatically. Now, let us understand. Termination of agency by death or insanity, and the duty of the agent. Under Section 209, an agency comes to an end when either the principal or the agent dies. or becomes of unsound mind. This is because the relationship of agency is based on trust and confidence, which cannot continue after such events. However, the law imposes an important duty on the agent. When the agency is terminated due to the death or insanity of the principal, the agent must take all reasonable steps on behalf of the legal representative of the deceased principal to protect and preserve the interests entrusted to him. In simple words, even after termination, the agent has a duty to act carefully to safeguard the property or business of the principal until it is properly handed over. So, remember, agency ends by death or insanity, but the agent's responsibility to protect the principal's interest continues for a reasonable time. Now, let us understand termination of agency by insolvency of the principal. Under the law of agency, as provided in the Indian Contract Act, 1872, an agency is terminated when the principal is adjudicated insolvent. Legal provision. As per Section 201, agency comes to an end when the principal is declared insolvent. Meaning of insolvency. Insolvency means the principal is legally declared incapable of paying his debts. Once this happens, the principal loses control over his property and affairs, and his property vests in an official receiver or assignee. Effect on agency. The authority of the agent comes to an end automatically because the agent acts on behalf of the principal, and after insolvency, the principal no longer has control over his assets. Important point. This termination is automatic. It does not depend on notice to the agent or even knowledge of insolvency. However, in relation to third parties, transactions done in good faith without knowledge may still have legal consequences. Example, A appoints B as his agent to sell goods. Later, A is declared insolvent by a court. In this case, B's authority immediately ends, and he can no longer act on behalf of A. Reason for termination. Because insolvency changes the legal status of the principal. Control shifts to a court-appointed authority, making continuation of agency legally impossible. Conclusion. So, remember, termination by insolvency ensures that once the principal loses control, no agent can bind him further, thus protecting creditors and maintaining legal certainty. Now, let us understand termination of agency on expiry of time. Under the Indian Contract Act, 1872, an agency may be created for a fixed period of time, and once that period ends, the agency automatically terminates. Meaning, when a principal appoints an agent for a specific duration, the relationship continues only for that agreed time, and once the time limit expires, the agent's authority comes to an end without any further action. Legal basis. As per Section 201, an agency is terminated by the expiry of the period for which it was created. Key features. Termination is automatic. No notice is required. The duration is predetermined at the time of appointment, and after expiry, the agent has no authority to bind the principal. Effect of expiry. The agent cannot enter into new contracts on behalf of the principal and must stop acting once the time ends. If the agent continues to act, such acts are not binding on the principal, and the agent may become personally liable. Example, A appoints B to manage his shop for 6 months. After 6 months, B's authority automatically ends, and if B continues to act, A will not be bound by those acts. Exception. If the principal allows the agent to continue even after expiry, then it may lead to implied renewal of agency or creation of a new agency by conduct. Conclusion. So, remember, expiry of time ensures that agency does not continue indefinitely and respects the time-bound intention of the parties. Now, let us understand termination of agency by agreement. Since the relationship of agency is created by an agreement between the principal and the agent, it can also be terminated by mutual agreement between the parties. This agreement may be express, either in writing or oral. Termination may also occur according to the terms of the agreement itself. Let us see how If the agreement provides that the agent is appointed for a specific period of time, then the agency will automatically end when that time expires. Similarly, if the agreement states that the agency will terminate on the happening of a particular event, then the agency will come to an end as soon as that event occurs. So, remember, agency begins by agreement, and it can also end by agreement, either by mutual consent or according to the terms already decided by the parties. Now, let us understand termination of agency by operation of law. In certain situations, the agency comes to an end automatically by law, without any act of the parties. This usually happens when the legal status of the principal or agent changes. For example, where the principal is a company, if the company goes into winding up, the agency automatically terminates. If a receiver is appointed to manage the affairs, the authority of the agent comes to an end. In cases of bankruptcy, the agency also terminates, as control shifts to a legal authority. Another important ground is frustration of the contract of agency. This happens when the performance of the agency becomes impossible or unlawful due to events beyond the control of the parties. So, remember, in all these cases, termination is not by choice, but by operation of law, because the continuation of agency becomes legally or practically impossible. Direct hit final takeaway. Agency can terminate in multiple ways, but when the law itself intervenes, the termination is automatic and unavoidable. Now, let us understand the effects of termination of agency. First, termination of subagent. Under Section 210, when the authority of the agent is terminated, the authority of all subagents appointed by him also comes to an end. This is because the subagent derives his authority through the agent. So, when the main authority ends, all subordinate authority also terminates. Second, agent's duty on termination. Under Section 209, even after termination, the agent has a responsibility. He must take all reasonable steps to protect and preserve the interests of the principal, especially in cases of death or unsoundness of mind. Now, an important exception. When agency cannot be terminated, under Section 202, if the agent has a personal interest in the subject matter of the agency, then the agency cannot be terminated to the prejudice of that interest, unless there's an express contract allowing such termination. In simple words, if the agent has something to gain or a stake in the subject matter, the principal cannot revoke the agency in a way that harms that interest. Direct hit final takeaway. Termination of agency also affects subagents. The agent still has duties even after termination, and in some cases, like agency coupled with interest, termination is not allowed. Now, let us understand illustrations under Section 202, that is, agency coupled with interest. Illustration A. A gives authority to B to sell A's land, and also authorizes B to recover his own dues out of the sale proceeds. In this case, B has a personal interest in the subject matter, so A cannot revoke this authority, and even the death or insanity of A will not terminate the agency. Illustration B. A consigns 1,000 bales of cotton to B. B has already made advances to A on that cotton, and A instructs B to sell the cotton and recover his advances from the sale proceeds. Here again, B has a financial interest in the goods. Therefore, A cannot revoke the authority, and the agency will not terminate, even by death or insanity. So, remember, when the agent has an interest in the subject matter, the agency becomes irrevocable to protect that interest. Direct hit key concept. This is known as agency coupled with interest, where termination is not allowed if it prejudices the agent's interest